Yes, good evening, everyone, all the participants. Thanks for taking out time and attending this session. I hope uh, at the end of this session you will have something new to learn. Obviously, mergers, as all of us know, nowadays is very widely practiced transactions. In the sense, you often come across such transactions. You keep hearing mergers, amalgamations nowadays when there is a lot of M&A activity going on in India and across the world. So we'll just start going. I mean, this topic is very specific. Like many of you would be aware that scheme of arrangement, as it is widely known, contains a lot of different provisions. It could be merger, amalgamation, demerger, and there could be different sort of arrangement and compromises between companies. But given today's topic, which is very specific to fast track merger, FTM, as it is widely known. So in terms of contents, what we will do today, we will just go through Companies Act provisions, because fast track merger is something specific to company law provision. In the sense, while say under the income tax law, or for that matter, under any other law, mergers are commonly known as merger, amalgamations, or scheme. But there is a specific provision under the Companies Act 2013, which is for certain specified companies. We focus more on that, like what are these provisions under the Companies Act 2013. Then we will touch upon some other key areas, like which is common for a merger, but specific to fast track merger, maybe something like say under the Income Tax Act, what precautions we need to take, or what are the key areas which we generally look into when we evaluate a merger, or so to say fast track merger. Similarly, stamp duty, GST, FEMA, and other statutory regulatory authorities. Then certain practical and operational challenges which say we may come across while we work on such transactions. So based on our past experience, we'll just touch upon that. And I would definitely invite all of you to just shed some light, whatever practical difficulties or challenges you have faced by way of a question or maybe inputs, and we can just take it up at the end. And as Prithiben said, we will have a Q&A along the way. In the sense, say, once we complete company law related provisions, whatever questions are there specific to company law provisions, we'll take it up, and then we'll go to the next session. So, taking it forward, like the provisions under the Companies Act 2013. So there is a chapter 15. So entire company law has been divided into different chapters. So there is chapter Roman 15, which is known as Compromises, Arrangements, and Amalgamations. As the name suggests, it is a very wide framework, very comprehensive framework, which enables M&A, mergers and acquisitions among the corporate entities. So it's not only specific to amalgamation or so to say fast track merger, but it is a comprehensive provisions. So which runs into from section 230 to 237 or so. So there are different provisions for different types of M&A activity. So out of that, section 230 to 232, as many of you would have come across, this is a very widely used provision, which is an NCLT approval rule. So widely used statutory framework. So section 230 is a very broad power which is entrusted to companies, which says that companies have power to compromise or make arrangements with creditors and members. So it is very broader in concept, in the sense it's not specific to only merger. It says that companies have power subject to certain provisions to make compromise and arrangement with its creditors and members. So it can be in the form of merger, amalgamation, demerger, capital reduction, or any other arrangement or compromise. So something like, say, company can also enter into a scheme to restructure its balance sheet or maybe buy out the minority shareholders. So it is a very broad framework, Section 230. So it is a substantive provision under the entire this chapter. 230 is something from which all powers are derived to the companies to do all activities under Section 230 to 237. So 231 is power of tribunal to enforce compromise and arrangement. So any such compromise and arrangement generally is subject to NCLT approval. That is the norm under Section 231. And 232 is specific to merger and amalgamation of companies, which is a normal provision, not a fast track rule. So any other merger or amalgamation which takes place between companies is generally done under Section 230 to 232, as you would have seen in a scheme of arrangement or related documents, you will often find reference of section 232, 232. 230 to 232. So meaning all these provisions are there through which companies are implementing such scheme of arrangement involving merger and amalgamation or demerger of companies. Now so this section 232, 232 are akin to section 391 to 394 of the Companies Act 1956. Say those of you who were practicing before 2013 and are aware about it. So under the Companies Act 1956, there were provisions called section 391 to 394. So those there are so when under the general clauses like an interpretation when we say what because in many law right now there is a old reference coming section 391 to 394. So when we have to cross refer it in Companies Act 2013, it would mean 232, 232. Where is section 233, which is the relevant topic for today's discussion, which is a fast track route without NCLT intervention for certain specified companies. So note that all companies are eligible to undertake fast track merger. There are certain specified companies. They can only adopt this route, which we will delve little deeper in the later on slides. So which is generally useful for smaller and closely held companies. So it is a simplified process which the government has introduced under the Companies Act 2013 with an aim to ease of doing business. As you know, there is a motto of government for ease of doing business. So this provision is towards that end, that you companies can quickly implement the mergers in certain specified circumstances without approaching the NCLT, which nowadays there are a lot of time-consuming activities with NCLT because generally, if you file an application with NCLT, it takes a lot of time nowadays because of IBC and all other provisions. And there are a degree of uncertainty when we have to file an application with NCLT. While there are certain standard time frame, but generally it takes longer than expected to complete a merger before NCLT. So in that sense, it is a blessing in disguise, Section 233, that given today's situation before NCLT, if eligible, companies can look for Section 233 provisions to implement fast track merger quickly without approaching NCLT. Then there are Section 234, which is merger and amalgamation of companies with foreign companies. So, which is not a subject matter of discussion today, but just to clarify that Section 233 language anything in Section 232, 232 of the Companies Act. Companies can do certain things, which is so Section 233 itself is a code in itself. So Section 234, which is merger and acquisition of company with foreign company, won't be possible. So to say for example, under Section 233, a holding company and subsidiary company can merge through a fast track route merger because those are the eligible companies. However, if this subsidiary company is located in the foreign jurisdiction, say it may be a wholly owned subsidiary only, but you can't do that merger under Section 233 because there is a specific provision under Section 234 which governs such mergers, outbound and in mergers. And Section 230 only overrides Section 232, 232. So this is the background about mergers and amalgamation provisions under the Companies Act. And now going forward, we will just focus on Section 233. So just to give some background about other ancillary and related provisions. Now, before we start discussing more about fast track mergers. So basically, there are like what we are going to cover in this session, in this section, so to say. Like Section 233 of the Companies Act is the only provision for fast track merger. So it itself is a code in itself. So there are Section 233 1 to 13, 13, 14 subsections are there. So entire provision is covered under this section itself. Then we'll just touch upon the key elements of a scheme of arrangement because say whatever we are discussing is to approve a scheme of arrangement, like reasons surrounds the approved scheme of arrangement. So what are the contents or elements in a scheme of arrangement? We'll just touch base that. And then there is a corresponding rule because say under Section 233, there are certain delegated powers to the central government, that government may prescribe certain things from time to time. So, which is covered by way of Rule 25 of the Companies Compromises, Arrangement and Amalgamation Rules, which is widely known as CAA rules. So, while all other rules under CAA rules relates to other scheme of merger and amalgamation like Section 232, 232, this is the only rule, Rule 25, which governs fast track mergers. So, in that sense, very less provisions to refer, like Section 233, one single section, and then there is a corresponding Rule 25, only single rule which we need to refer. No doubt there are certain cross references in Rule 25 or 233, which we need to invariably take care. But in terms of provisions under the Companies Act, it is very brief. So now, while we have almost touched upon what is Section 233, it is a fast track merger, newly introduced provision under 2013. However, one distinction which we need to be mindful when we discuss through all these provisions, while the language, so this is the heading of section, merger or amalgamation of certain companies. This is a title of Section 233, but don't go by the title, because it's not only merger or amalgamation which you can do under a fast track merger. Companies can also do demerger or other compromise or arrangement. So Section 233 subsection 12 says that, while if you read entire section right from 233.1 till 233.11, it will refer to merger and amalgamation, but it in 233.12 it says that provisions of this section shall mutatis mutandis apply to a demerger scheme or other compromise or arrangement as referred in section 232 or 230. So while generally we will refer it as merger and amalgamation, but we need to be mindful that this section 233 can also cover demergers and other sort of compromise and arrangement between eligible companies. No doubt that provision remains. So now, which are the companies they can adopt this route? So Section 233(1), as we just discussed, it is an overriding provision which overrides Section 230 and 232 and says that a scheme of merger and amalgamation may be entered into between two small companies. As all of us would be aware that under the Companies Act, there is a concept called small companies, which is certain threshold over and criteria. So the smaller in size, so so that stakes are higher, stakes are not involved. So those companies can adopt this route. Then there is a merger between holding company and wholly owned subsidiary company. So vice versa is possible, like merger of holding company into WS or merger of WS into holding company, because between holding company and WS. So there is a flexibility under the law that you can merge holding company into WOS, wholly owned subsidiary, WS as we call it, or WOS into holding company. So these are the two categories of companies. And then Section 233(1) says that such other class of companies as may be prescribed, subject to provisions of 233(1)(a) to 1D, which is a substantive provisions, which we will take it up in the later on slide. But conceptually, so these are the two category of classes of company, and there's no interlinkages. So it's not like a small company and a hold. So between two small companies, you can do it. Between holding and wholly owned subsidiary, you can do it. And then Rule 25(1)(a), which has been notified under, which has been enacted under CAA rules, pursuant to powers vested under 233(1), which says that apart from what is stated in section, two or more startup companies is defined in the startup notification of 2019. So there is a notification which government has issued, central government has issued, and which defines the startup companies. So there are certain criteria to be fulfilled, and then such companies can register with DIPT, a department of as a startup company. So they need to be a registered startup company. So generally, any company which is incorporated after 2016 until 10 years, they can be a startup company so long as their turnover does not exceed 100 crore. And apart from many other criteria which is stated in that notification. So assuming if there are startup companies, though they are not wholly owned subsidiary or holding company, maybe two independent startup companies are there. So in the new age companies, there are a lot of companies coming up. And if say they want to merge, maybe there are two distinct companies operating in different fields and not connected with each other, having independent shareholders, management. But if startup is per definition, they can adopt this route to merge both the companies under section 233(1). So this is a third category of company. And then there is an interlinkage under residual category, which says that one or more startup company with one or more small company. So again, if company A is a startup company and company B is a small company, though may not necessarily be a startup company, still company A and B can merge under the section 233. So these are four broad categories. So between two small companies, between a wholly owned subsidiary company, between two startup companies, and then between a startup company and one or more small companies. So this is the universe within which try to adopt a scheme of merger under a FTM provision, fast track merger provision. So any company which is not covered by these provisions, they have to follow section 232, 232. They cannot adopt this route. So this is the limited universe. So I think there is some question. I think we'll take it up later on. Maybe any one of you have any questions, you can put in Q&A session, chat box, and we'll take it up. So then taking it forward, before we go into specifics of section 233 and rule 25, we'll just touch upon the key elements of a scheme of arrangement. So like what is the scheme of arrangement and what are the typical contents which we generally see? Because this would be a document which companies would generally adopt, say in a board meeting or members meeting, and then this will govern the entire merger provision. So demerger, or so to say, scheme of arrangement. So it is in a way contractual document, like say we have agreements, right? Say something like sale deed, purchase deed, or maybe share purchase agreement. It is a agreement, contractual agreement between two parties, which is enforceable under law. Similarly, though it is not in a typical agreement format, if you had an occasion to come across a scheme, you will see that there is a typical way in which scheme is drafted generally. So it's not in the form of an agreement. So while a general norm would be like, if you come across such document, I mean, perception wise, you may not feel it is a agreement, but technically, it is an agreement between companies and its shareholders and creditors, which is a contractual document which covers all provisions in a codified way. So generally, what's the context of scheme arrangement? So it starts with background about the company. So like say transferor company and transferee company is there, then you will have some half a page description about the transferor company and transferee company. Basically, the date of incorporation, registered office, the business activities it is doing, and then directors, shareholders, some big brief background about the companies, and then you have. So it can be there can be multiple parties involved in a scheme. It's not necessary there could be only one transferor and transferee company. You can have a composite scheme of arrangement as well, wherein more than two companies are involved. Say maybe four wholly owned subsidiary companies are getting merged into the holding company, or maybe two or more startup companies are getting merged with one startup company. So things like this could be there, or even there could be a composite scheme of arrangement wherein say there could be a merger of two startup companies, and then there could be a demerger from that startup company into a small company or vice versa. So those all combination is possible in this. Then you have a rationale of the scheme. Generally, a scheme document will have a rationale. So, like, what are the objectives and need for such scheme of arrangement? So, companies generally need to be mindful about capturing all commercial objectives, because from income tax perspective and many other statutory and regulatory requirement perspective, it's essential that you have a commercial objectives clearly listed down in the uh, document, because it can be referred by say regulatory authorities tomorrow that what was the rationale or objective for companies to adopt a scheme of arrangement, because there are provisions like GAR, general anti-avoidance rules. So unless objectives are very clearly stated and then there are commercial expediency needs, there is a possibility that income tax department may challenge such schemes on the ground of commercial substance, or so to say, commercial expediency needs. So we have to be very mindful about, while a lot of other things are very standard in nature when you look at a scheme of arrangement, but rational is something you need to be very careful, and you need to cover the essence of the scheme or objectives of the scheme in a very nicer way, so that whenever you have to defend yourself, in the sense companies, why such actions were taken. So this para should be a self-explanatory thing, and it should not be like something afterthought process is there. In the sense, if you have documented in the scheme what you intended, you can always tell a regulatory authority that this was the thought process even before the scheme was conceptualized. So it is very important that we cover all relevant need, objectives, or rationale in the document. Then there are a lot of definitions which are being used in the scheme document, which is defined. So one of the some key definitions are like appointed date and concept of effective date. So like say in a scheme of merger, you can always have an appointed date, meaning that while scheme is subject to regulatory approvals, meaning say today if we approve a scheme in a board meeting, which is subject to multiple approval processes and which takes say 4 to 5 months down the line. But you can always have a date mentioned in the scheme that whenever this scheme gets approved, and that approval date is generally known as effective date, when scheme is finally approved by the final authority, say RD or central government in this case, and that scheme is filed with ROC, that date becomes the effective date. So I mean, from that day onwards, scheme comes into effect or operation. But then from which date it will come into effect? So that is the appointed date. In the sense, you can have a retrospective effect of such scheme of arrangement. In the sense that today we are in the month of November 2024, and today if we approve a scheme of arrangement and we want to implement this scheme with effect from say April 1, 2024, then you can build that provision in the scheme saying that appointed date under the scheme shall be April 1, 2024. So whenever scheme is approved after all processes, after say 4 5 months, it will take effect from the appointed date. So the transferor company shall get merged into the transferee company from the appointed date, though effect would be given from effective date. So this is very critical thing in a scheme of arrangement, which from various objectives perspective, it is generally critical. And then there are MCA guidelines on this, that generally when scheme is approved by board, the appointed date should not be antedated beyond 1 year. So, like say, there are instances which we have come across in past, wherein clients wanted to do a scheme and make it effective even beyond the period of 1 year. Say today in 2024, if you are evaluating a scheme for certain commercial objectives, because say client wanted to do that merger effective with effect from 1st April 2022. You are formulating the scheme today, getting it approved in the board, filing it with the authorities, you are mentioning appointed date as April 1, 2022. So, so it is possible. So general norm is appointed date should not be antedated beyond 1 year. But then it says that if it is beyond, if the appointed date is beyond 1 year, then companies should provide justification why they want to keep appointed date beyond 1 year. And in some cases, we have been successful in getting a scheme approved, which was having appointed date of say even 2 years before. There was certain rationale behind that. So there has to be some commercial justification, and you will have to effectively coordinate and liaise with authorities to get it approved. Otherwise, generally, it is a challenging thing to approve a scheme having appointed date beyond 1 year. And then there are very standard provisions like transfer of undertaking. Entire whatever assets and liabilities are there in the transferor company, that will get merged with the transferee company. Then transfer of contract, transfer of employees, any litigations are there, that will be. So everything is subsumed by the transferee company, in the sense surviving company, or so to say amalgamated company. So whatever is there in the transferor company or amalgamating company will become the asset, liability, contracts, employees, litigation of the transferee company. So that is the effect of scheme, that whenever it is approved, the entire asset, liability, all such rights, obligations effectively gets vested in the transferee company. Then there is a share exchange ratio provision, because in a way, say a assuming there is a merger between two small companies or maybe two startup companies, then what will happen that we will have to undertake the valuation of both the companies, right? And basis that, shares will be issued by the transferee company to the shareholders of the transferor company. So assuming there is company A and B, both are in startup segment. Now, when merger gets effective, we will need to know like how much each shareholder owns in the combined entity. So say for example, fair value of company A is 100 and fair value of company B is also 100. Then in the combined entity, both the shareholders will have 50% ownership each. So that is the share exchange ratio which we'll have to determine, and which will be specified in the scheme of arrangement, that whenever the scheme gets effective, the transferee company will issue shares to the shareholders of the transferor company, and how much shares will be issued. So that is governed by this share exchange ratio based on the capital base of each company and the relative fair value, and which is generally determined by a registered valuer. So generally, registered valuer report. However, say if there is a merger of wholly owned subsidiary company into holding company, there won't be any valuation, because say, technically the wholly owned subsidiary WS is owned by WS itself. So when WS gets merged into holding company, shares will get cancelled, and because the holding company itself is a shareholder, so technically you don't need any valuation report when there is a merger of wholly owned subsidiary company into the holding company. Then, apart from that, in most of other transactions, like between two startup companies, small companies, or between small and startup company, you will invariably need the valuation report. Or say even in a case of demerger between holding company and subsidiary company, you will require a valuation report, because there will be a different dynamics and you will need to have the valuation report in place. Then we have a accounting treatment. So generally, scheme specifies that when the scheme becomes effective, what accounting treatment transferee company would follow. So say under the accounting standard norms. So we nowadays we have two accounting standard framework. One, we have the old accounting standards, and then we have Ind AS. So under the old accounting standard, we have AS 14, which generally has two accounting methods: pooling of interest method and purchase method accounting. So there is a possibility that in such scheme, both the methods can be followed. Either method can be followed, in the sense, say, scheme can provide that merger will be accounted as per pooling of interest method, meaning all assets and liabilities would be recorded at book value only. There won't be any changes in the carrying value of assets and liabilities, and the balance amount is adjusted in goodwill or capital reserve, depending on the share capital base. Versus you can have a purchase method of accounting, wherein the transferee company may account the assets and liabilities of the transferor company at fair value, and the resultant difference can be adjusted in the capital reserve or goodwill, as the case may be, subject to obviously keeping in mind other provisions of law. So this what I just discussed is about accounting standard. Whereas if you talk about Ind AS, there is Ind AS 103, which talks about business combination. And under business combination, if there are companies under same management, companies controlled by the same management or same parties, then you have to mandatorily follow the pooling of interest method. So all assets and liabilities and reserves has to be transferred at a carrying value only. And so common control, as it is entities under common control, as is widely known. Appendix C under Ind AS 103 governs such mergers, and you will not have that option available to account such mergers at fair value under Ind AS framework, whereas that flexibility is available under the normal accounting standard till date. Uh, so then there are aggregation of authorized share capital. So like whatever authorized share capital is available with transferor company, that can get consolidated in the transferee company, because many times as you may be aware, that there is a substantial cost involved in the authorized share capital. So if for example, if transferor company has a authorized share capital of 10 crore rupee, and it has paid fees on that, so it can always, as part of scheme, it can consolidate that authorized share capital in the transferee company. The scheme can provide such provisions in the document, and Section 233 also recognizes such provisions. There is a statutory enablement for such matters. Then dissolution of transferor company without winding up. So what happens when scheme gets effective on the effective date? Transferor company will cease to exist. In the sense, it will dissolve without the winding up process. So, I mean, scheme, it is a single window process. So you don't need to follow a separate winding up process for that. Once all procedures are implemented, the transferor company cells stand dissolved without the winding up process. And so these are the some of the key contents of scheme of arrangement. So whenever you come across such document, it runs into generally 25-30 pages. And out of that, these are the very key provisions. And obviously, depending on facts specific to a client or companies, there could be many more provisions which you can adopt. So there is no statutory guidelines under the law that what all a scheme can have as a content. So long as whatever you want to cover in a scheme of arrangement, so long as it is not void or illegal, you can always build that in the document. Obviously, you will have to be mindful that whatever you are trying to write in the scheme of arrangement in the document should be plausible in the sense it should withstand the test of regulatory and judicial scrutiny. So you can't just write anything you wish to, because tomorrow there are regulatory authorities which will scrutinize such scheme. So to say, for example, you can't write there were past violations in the transferor company, and then you now in the scheme you say on the scheme becoming effective, all past violations will become regularized. You can't have such provisions in the scheme document. But anything relating to transitional provisions, basically the amalgamation or consolidation of two entities, you can build in the scheme document. And this scheme is subject to contractual and regulatory approvals, which we will definitely run through in terms of FTM provisions. So these were the contents of the scheme. So we have some questions coming up in the Q&A session. I will just have a look at quickly. So Chandrasekharji is saying turnover and capital is under the limit mentioned for small companies, but one company has a subsidiary outside India. Is there a way to consider under fast track merger? So technically, as we just mentioned, Section 233 overrides provisions of Section 232, 232, whereas subsidiary which is located outside India, and if you want to explore a merger with that company, there is a special provisions under Section 234 for inbound and outbound mergers. So definitely you can't do that under 233, though you may be, both the companies may be eligible in terms of criteria. So something like the company which is outside India is a subsidiary, also a small company, but still you can't merge that company with the holding company because that is governed by special provisions, because then there are FEMA provisions which comes into picture in such case. And then there are increased regulatory scrutiny and provisions around that. So you can't do under 233. Second question is, I think both the questions are more or less on same grounds from Chandrasekharji. That so conceptually, Chandrasekharji point is, if foreign companies are involved, either way, in any form, you can't do that merger under FTM provisions. There is Section 234, which has a separate provisions and procedures which you need to follow. So I think both the questions are answered in that sense. So now, taking it forward, as we just
There's
discussed
one more
earlier.
question. Ankit,
Yeah,
here, there's one more
please.
question from Saili. Says, what if holding company is merging with its wholly owned subsidiary? Will the valuation report be exempted in this case as well?
Okay, Prithimendu, you are saying wholly owned subsidiary company is getting merged into the holding company, right?
No, holding is merging with WOS. It's a reverse merger.
Yeah. Okay. So in that, Prithiben, there are like say concept. I will just so quickly touch upon that aspect. So what happens generally that when holding company merges into subsidiary company, the technically the shares which are held by holding company needs to be cancelled. Say for example, in holding company there are 10,000 shares held by four individuals, 2,500 each, and holding company is also holding 10,000 shares in the subsidiary company. Now, when holding company merges into subsidiary company, the 10,000 shares which are already there and which is held by holding company will have to be cancelled first. Because a holding company cannot, continue to hold those shares. And then subsidiary company will have to issue new shares to the shareholders of the holding company. So here there are two practices which is being followed, Prithiben. So long as there is a mirror shareholding concept, in the sense the scheme can provide that there will be a mirror shareholding, like the shareholders who are holding shares in holding company, in the same fashion they will continue to hold shares in the subsidiary company. Or for certain reasons, like say sometimes we want to follow a different share exchange ratio for certain objectives, like say we want to have a different share capital base in the subsidiary company through a merger process as well. So in such cases, and generally, while say technically you need not do a valuation process per se, but generally as we practically have seen that RD, ROCs and regulatory authorities generally ask for it. So generally instead of valuation report, what we have a fair share exchange entitlement ratio report. In the sense, valuer would say, because there is a mirror shareholding between holding and subsidiary company, there is no need to do any valuation process. And so long as shares are issued in the ratio of 1:1 or any exchange ratio, say 1:1, 1:2, that exchange ratio will be fair and reasonable, because all shareholders would become shareholder in that ratio only. So technically, valuation need not be done. You would see a lot of valuation reports are also available in public domain for listed companies. So the value, generally we take a valuation report because otherwise it is difficult to explain regulatory authorities. But technically, such reports are not valuation report. There is no valuation method or process followed. Rather, valuer generally refers scheme and says that since it is a mirror shareholding, and any ratio would be a fair ratio. And we have such report which we submit with the regulatory authorities, so that process becomes little smooth in that sense.
Noted. Ankit,
Process becomes,
there are some more questions in the question Q&A box. Yash is saying, is the merger of step-down subsidiary with its ultimate holding company possible through fast-track merger?
yeah, correct. So you mean to say within India only, right? Within India, ultimate subsidiary company.
Yeah.
So technically, as per the definition under the company law, there is no distinction between step down and immediate subsidiary company. So technically, so while in general common parlance, we generally refer it step down subsidiary, but as per the definition, a step down subsidiary is also a subsidiary of the holding company. So it would be, you can always do that merger. However, generally you have some operational challenges. What happens, say in such case, there is company A, B, and C, right? So A is holding B and B is holding C. Now we want to merge C into A. So technically under 233, you can do this. So right now we are just focusing our discussion on company law provisions only and not touching upon other provisions which we need to independently evaluate. So something like income tax provisions. So there could be some limitations to do such mergers. But right now we are just discussing company law provision. So C can be merged.
It is possible. Under we may face certain challenges or okay.
Yeah, because section 2(1)(b), we need to comply with certain conditions. So there are some practical difficulties which we face. Otherwise, 233 is doable. Yeah.
There's one more thing that says, taking forward Chandrasekhar's question, you can transfer shareholding, make it WOS holding company, and then apply for merger with no substantial tax on transfer. Okay, that is actually an extension of the first question, which you answered for foreign company, foreign subsidiary. There's one more question. It says, what are the sequence of activity in terms of timeline in the previous slide?
Yeah, we have a timeline which we will take it up later on. So after we complete section 233 and related provisions, we have 2 slides shown in a summary form. What are the timelines? So we'll touch base over there. Right now we have just seen the scheme contents. Timelines will follow later on. Yeah.
Okay, now please go
ahead. Yeah. So we'll continue. Can you please repeat, ma'am? Okay. So now we just go into the specific provisions under the company law, section 233. So as we just discussed earlier, section 233, 1 to 14, some 13, 14 subsections are there, which covers the entire provision. And initial 6, 7 subsections are key, and later part are the effect of scheme and corresponding rules. So we are trying to take it up both together so that we have a holistic understanding like what section requires and what are the provisions in the rules. So as we earlier discussed, section 233(1) is the substantive provision, like what all companies can follow these provisions. And then it is subject to provisions of section 1A to D. So I think this is the very crux or heart of the provisions which we need to comply with. And other things are like, you can say in a way, ancillary or process to be followed. So what are these four key provisions? While initial two are procedural in nature, again, B and D could be very significant to understand. So like under 233(1)(a), it says that before company so basically before company approves a scheme of arrangement, companies should send notice of the proposed scheme inviting objections or suggestions from the ROC and OL or person affected by the scheme. So this is the language of section. So when we say provision, whatever is written in the law, we are just trying to refer. And obviously, practically, what we need to do that we also discuss simultaneously. So technically, section 233(1) says that before you formally approve a scheme, you need to send a notice inviting objections and suggestions on the scheme from the ROC and OL and person affected by the scheme. So it is a very wide language. So any person which can be affected by the scheme, you need to send the notice to them. So generally what we do, we send notices to RD, regional director. Then you have income tax department, GST and sectoral regulators, depending on the status of the company. So if there are listed companies, you need to send notices to BSE, NSE, SEBI. Obviously, there are SEBI regulations which govern such merger, which we'll have to just discuss. We'll just touch upon that separately. And then if say it is an NBFC, you need to send notice to the RBI as well. If it is an insurance company to IRDA, if it is a real estate company, maybe RERA authority. So any person which could be reasonably deemed to be affected by the scheme. So any regulated entity generally would mean that you need to inform the regulator, concerned regulator. So this is the notice which you need to send, and there is a form prescribed under Rule 25(1), that CAA9. It is a very standard form which generally says that these are the companies which are proposing a scheme, and obviously we'll have to attach a draft scheme so that regulator has a perspective of what the companies are planning to do. And then you just need to ask them, like, if you have any objections or suggestions, please send it within 30 days. So language is like that. And then, so sequentially, we have just taken up section 233(1)(c) first, because B and D are related provisions and A and C are related provisions. So, and under 233(1)(c), it says that each company is involved in the scheme. So, whatever be the number of companies which are involved in such scheme. So, basically, I mean, companies which are part of the scheme of arrangement, 1, 2, 3, 4, 5, as many as in number, each of them need to file a declaration of solvency with jurisdictional ROC. Uh, uh, Jurisdictional ROC, and there is a rule 25(2), which says that declaration of solvency needs to be filed in CAA 10. And languages in rule, it says that before convening the meeting. So meaning under B and D, there is a process relating to convening of meeting of members and creditors. So before you do initiate activities on B and D, you need to complete A and B, subsection A and C, so to say, that you need to file this notice with concerned authorities or person affected by the scheme in CAA 9 and declaration of solvency in CAA 10. So what practically we have seen that when we say declaration of solvency, so RD, ROC, they generally say that if a company has a positive net worth, then the declaration of solvency is valid. While say it is an technically it is a statement which board is adopting, that looking at all state of affairs of the company, we are of the opinion that companies are solvent. Now, it is quite possible a company is there, it is a non-operational company, it may have some negative net worth. Say, for example, maybe 5, 10 lakh rupees, 25 lakh rupees. That does not mean it is not a solvent company. I mean, because there are shareholders, management which keep supporting such company. But technically, what RDs, ROCs have been taking stand that if you have a negative net worth, then you can't, your declaration of solvency is not valid. So practically we face these challenges that when there are small companies or startup companies, And if any of those companies have negative net worth, then technically it is very difficult to follow these provisions. While say while we touch upon, so like there was a case law because it is a related thing, so I will just touch upon this quickly. Uh, Assuming they say there is a company, transferor company, which is having a negative net worth, but transferee company is a holding company and there is a subsidiary company, right? Now, transferee company is a substantive positive net worth, say something like 50 crore rupee, and transferor company has a negative net worth of maybe 1 crore. So, and assuming that transferor company adopts this declaration of solvency based on these parameters, like we are supported by the holding company and we are solvent, and as and when needed, holding company can support us, and in that sense, we are a solvent company. Now, the companies may go ahead and file the application with RDROC. Now, generally, RD's ROC go by the letter of the language saying that no, you can't have a declaration of solvency. So there was a similar case law, which we have referred in the subsequent slide, wherein RD rejected such scheme of arrangement, saying that you are not, the application is not in order as per section 233(1)(c). But if you look at entire section 233 as we go along, RD does not have a power to reject the scheme. Either it can approve the scheme or it can refer the scheme to the NCLT. That scheme be considered under the section 232 as per normal provisions. So, I mean, Bombay High Court has upheld that under the provisions of section 233 RD. So basically, language of section is central government, and all powers under central government is vested with regional director. And in that sense, RD cannot reject the scheme as per the judicial precedent as it stands now. So there is a leeway available depending on the facts specific to a situation. Then we have 233 1B and D. Now, again, very key provisions. It says that objections and suggestions received are considered, in the sense whatever, say, under 233 1A you have issued notice to RD, ROC, OL, RD and other regulators, and whatever objection suggestions you receive are considered by the companies in respective general meeting. So meeting must be of respective class of shareholders. So if there are different class of shareholders, companies will have to do separate meeting for each class of shareholder, and such objections and suggestions are considered in that meeting, and scheme is thereafter approved by members holding at least 90% of the total number of shares. Now, be mindful over here, generally under the company law, as the provision stands, like whenever you have a general meeting, so voting, whenever we say general resolution or special resolution of 75%, so parameter is like whoever is present in voting, you have to consider for you have to consider the approval for those people only. So say for example, in a company, if there are 10,000 shareholders holding 1 crore shares, and only 1,000 shareholders attend holding 50 lakh shares. So that resolution is considered based on the person who is present and voting in general norms. But under section 233 1B, that will not work because it says that scheme needs to be approved by 90% of the total number of shares. So it doesn't matter whether members are present in such meeting or not. You will have to ensure, companies will have to ensure that scheme is approved by 90% of the total number of shares. And because of such reasons, you would often see that many times listed companies are coming up with scheme of arrangement wherein they are proposing merger of wholly owned subsidiary company into the listed company. And still they are not following section 233 route. Mainly because of this limitation, because as you know that in a listed company, ensuring that 90% of the total number of shares vote in favor of the scheme is very difficult, because generally shareholders don't participate in such meetings. Only promoters, and then there are institutional investors who participate, and securing 90% majority is very difficult. And because of that, though technically a listed company, being a holding company and having subsidiary company, though they may be very large in size, both the companies, still they are eligible to merge under section 233 as per the language, holding company and wholly owned subsidiary company. But because of section limitations under 233 1B, often we have seen companies are unable to effectively use such provisions, listed companies. So in that sense, only smaller and closely held companies can effectively use such provisions. And similarly, under 233 1D, you have unit. So there are again different criteria. It says that scheme is approved by majority representing 9/10 in value of creditors, meaning at least more than 50% number of creditors which hold 90% in value should approve the scheme. So here there are two options available. Either you can have a meeting of creditors, or even such approval can be taken in writing. So generally you have a consent letter consent. So by way of an affidavit of consent letter, creditors can give approval to the scheme, and you need not necessarily have a meeting of creditors under this provision, because it says it otherwise approved in writing. However, under 233(1)(b), there is no leeway given for approval in writing. You will have to mandatorily conduct a meeting of shareholders, and reason being because you need to put forth all objections and suggestions of regulatory authorities before the members. So that is the language. And Rule 25(3) says that notice which will be issued to these members and creditors should have this ABC. So ABC section 233 covers a very detailed requirements, like what all contents should be there in a notice of meeting read with Rule 6.3 for normal merger and so regular merger and amalgamations under section 232, 232. So there is a cross reference under Rule 25(3) that such notice should also have contents or statement as specified under section 230 subsection 3 or rule read with rule 6.3 of CAA rules. Also declaration of solvency which companies would have adopted under subclause C, and copy of the scheme. So here there is a catch, like say the language is you need to issue 30 days notice to these regulatory authorities. So there are two ways possible that companies first issue notices to regulatory authorities and wait for their objections and suggestions to receive, and then send notice to the members, because like whatever objections and suggestions are received, you need to consider before the members meeting. So technically you will specify that in the notice and then dispatch the notice to the members. And then there is a requirement of 21 days notice criteria when you want to conduct meeting of members and creditors. So you will need to wait for 30 days and then have 21 days notice period and then have the meeting maybe at after 51 days or maybe at around 55 days. Whereas there is another view possible which says that while you can issue the notice to the regulatory authorities, say on X day, and on X plus 1 day, say you issue notice to the members saying that meeting of members or creditors would be held on X plus 35 day. Right now, what will happen? Your notice has gone to the members and shareholders saying that meeting would be conducted on X plus 35 day. And on the other side, on X day, you had already dispatched notices to regulatory authorities. By the 30th day, if they want to make any objections or suggestions, they have to make. And if they don't give any suggestions, it will be deemed that they have no objections to make on such scheme, OL, ROC, and RD and other regulators. And then whatever suggestions are received, company can always disseminate that to the members before the meeting and then discuss that in the meeting and get it approved. So both approaches are possible looking at the so in the second approach you can save on time, that within 35 days you can have objections and suggestions of regulatory authorities and as well as conclude the meeting of members and creditors. So section 233(2). So after scheme is approved by, say, once you follow all processes under 233(1) ABCD, so we are on X plus 35 day when member has already approved the scheme. Now, transferee company will have to file copy of scheme so approved with the central government, meaning RD, ROC, and OL, in the manner as may be prescribed. So it says that now CAA 11 is there with RD we need to file. And there is a RD1 electronic form which we need to file that application. CAA 11 is a physical form, and in RD1 electronic form we will file that application. And here we need to be very mindful that this application needs to be filed within 7 days of conclusion of meeting of members or creditors. And these timelines are little critical. In one of the practical case, what we have come across that since this application was not filed within 7 days, RD had rejected the scheme, saying that it's not as per the procedure. So obviously these are very procedural in nature. So we have to be mindful that within 7 days you file that application. And under 24B, it says that the scheme to be filed with ROC will be in GNL1 in electronic form as well as physical form. Physically also we file. and with oil through hand delivery or registered post. So this is the procedural provision that one scheme is approved. You file this scheme with RD, ROC and oil in CAA 11 along with applicable electronic forms GNL1, RD1. Then section 233(3) comes into picture, wherein it says that on receipt of the scheme again. So while say earlier you had given 30 days advance notice to ROC and OL, and generally practically what we have seen, none of the authorities come up at that time within that 30-day time frame. And if at all they want to make any representation, generally they would make here under 233(3). Again, there is a 30-day timelines wherein if ROC or OL, so obviously over here person affected by the scheme. So obviously there are they want to make a representation, they may have to do within that advanced 30 days window only. Here under 233(3) only I mean powers are given with ROC and OL that they objections or suggestions to the central government, meaning RD, and whatever objections or suggestions ROC or OL has, they can make it to the RD. And Rule 25(5) says that say if within 30 days, if ROC or OL does not come up with any objections or suggestions, and if central government is of the opinion that scheme is in the public interest or in the interest of creditors, these are the two parameters for central government, or so to say RD, then within 30 days, so ideally, it says that within 15 days of expiry of 30 days, so technically within 45 days, RD needs to issue a confirmation order of such scheme in CAA 12. So CAA 12 is a one-pager order which just confirms that the so-and-so companies have filed an application and this is approved subject to certain conditions. So generally, they prescribe some standard on accounting treatment and certain other things, but it is one-page order only, unlike NCLT order, which runs into generally 5-10 pages. So it is very simplified process. And it says that if say center, if RD does not take actions within 60 days, meaning once you file an application with ROC, application with this ROC RDOL, 30 days time frame for objections and suggestions, and plus 30 days time for RD. If RD does not take any action within this time, then it shall be deemed to be approved. However, RD will need to issue a confirmation order. Deemed approval does not mean without any document also you can say it is a deemed approval. Language of the section is it shall be deemed to be the it shall be deemed that RD has no objection to the scheme and it shall issue a confirmation order. So it becomes a binding and obligatory on the part of RD to issue a order. Say if within 60 days RD doesn't take any action, so legally companies can always enforce RD to issue a order without any further process. So these are like towards ease of doing business provisions deemed approval within 60 days. But practically what we have seen, RD would generally issue a letter, whether it receives objections from RD or ROC or OL. On its own, RD will have certain queries and questions and companies will have to address that. So that way process is live and up. So it generally remains live like that way, and it doesn't strictly gets completed within 60 days. Generally, RD will issue a letter, company will submit response. Again, they may have some incremental queries. So in that sense, while if everything goes in order and if companies are able to convince RD that everything is in order, it is possible that within 60 days you can have that order. But and that's more of a representation before RD and how effectively you are able to get it done. Or otherwise, it may take time. So technically, generally RD may take it may issue 2-3 notices and each notice may take 30 days. So generally it may run into 60-90 days process as well. So now 233(4) is a different provision. It says that so while 233(3) is like ROC and OL has no objections, then it is deemed approval. In 233(4), it says that ROC and OL has some objection and it has communicated to the RD within 30 days. Then also RD has options. Either it can consider the objections of ROC or OL, or it can set aside. Meaning it says that if RD believes that it is not sustainable, whatever objections and suggestions ROC and OL has given, and the scheme is in the public interest or interest of the creditor, then still RD can go ahead and issue the order. So 233(3) ROC OL does not issue any objections, and then RD will go ahead and issue the order. In 233.4, it says that ROC or OL has some objections, but still RD believes that such objections are not sustainable. And in opinion of RD, things are in order. Then it can issue the confirmation order under CAA 12. Now, section 233.5 says that if RD believes that scheme is not in the public interest or in the interest of creditors, either based on the objections or suggestions of RDROC or for any reason. So there is a wide power again over here. So it says that either based on the suggestions or objections which ROC and OL has given, or otherwise, or for any reason. So like say RD can have its own opinion that though ROC OL has not raised any questions, but if RD feels that things are not in order and it is not in the public interest to approve the scheme, or in the interest of creditor, something like declaration of solvency case, which what we just referred, that transferor company has a negative net worth. Still, companies have given declaration of solvency. Now, RD believes that this is not a correct way. It is not in the interest of creditors that these companies get merged, because then negative net worth company will get merged with the positive company having positive net worth. So, so in that case also RD can RD can, so point is RD does not have power to reject the scheme. So what it can do, it will have to make an application before NCLT within a period of 60 days from the date of filing application. So again, timelines are 30 plus 30 days only. 30 days RD need to wait for ROC and OL, and within next 30 days, either RD has to approve the scheme in under 233 3 or 4 subsection by issuing order of confirmation in CAA 12, or RD is to refer the matter to the NCLT along with its opinion that why RD believes that such scheme is not in the public interest or interest of the creditors, and stating its objections. So RD has to say what objections it has, and requesting that NCLT may consider the scheme under 232. So it says that, and RD has to refer it to the NCLT saying that these are my objections and you may consider the scheme under 232. And that application needs to be filed by RD itself under CAA 13. So these are the only forms, CAA 9 to 13, which you will come across. And again, there is a language of deemed approval that if RD does not issue order of confirmation in CAA 12 or does not file application with NCLT in CAA 13 within 60 days, then it shall be deemed to be a deemed approval and RD will have to issue the confirmation order. So these are the processes. So now what happens once matter has been, so assuming if RD approves it, the other things will follow, meaning companies will get the order of confirmation of scheme, and then companies will have to take other actions like file the order with ROC 9C28, which we will just discuss later on. Maybe under 233.7 also it is referred. Or if RD has referred matter to NCLT, then what NCLT needs to do, that is mentioned in 233.6. So NCLT decision on the scheme. So what it says that on receipt of application from central government or from any person. Now here again, a very critical thing, like say, like in a situation what we just discussed, that RD rejects the scheme and it does not file an application with NCLT. Then transferor companies, so basically companies involved in the scheme or any person which is affected by the scheme, maybe say shareholders, because some of the shareholders want these companies to be merged or creditors, then they can also file an application with NCLT saying that this was the scheme which was put up before RD and RD has rejected it. Now you please consider this scheme under 233.5, because under 233.6, if RD does not file that application, then other person can also file that application with NCLT. And if NCLT, for reasons to be recorded in writing, so NCLT will record its reason, and either it will uh, 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 direct that scheme be considered as per the procedures laid down in section 232, which is a long procedure. Again, I mean, the entire matter will get revived and companies will have to follow section 232 process. Or NCLT may confirm the scheme by passing such order as it deems fit. So not necessary that even though, like say something like declaration of solvency, again that one case law which we have, in that case what NCLT did, NCLT approved the scheme it did not ask companies to follow Section 232 route. It says that it upheld that given the transferee company has sufficient net worth, though transferor company has a negative net worth, post merge entity, I mean, it will not affect the interest of creditors or public interest. And accordingly, NCLT approved that scheme. So that is the power which NCLT has under 233(6). Not necessary that it will be followed under the scheme will have to be mandatorily passed through Section 232 provisions, but on its own merit. And given that say a substantial majority of shareholders and creditors would have approved such scheme, right? 90% plus as we just discussed, and board of the companies would have approved it. And if there are no objections from any other regulatory authority, assuming and on technical grounds, RD, ROC, or OL is objecting to such scheme, then NCLT can still approve such scheme and set aside the procedural requirements, because in substance, it should be okay. So the NCLT has that wide powers under Section 233(6). And then Section 233(7) says that order of copy of order confirming the scheme from either NCLT under Section 233(6) or under 233(3) and 4 from RD shall be communicated to the ROC having jurisdiction over the transferee company. So meaning the order will be needs to be filed with ROC in INC 28, saying that this merger scheme has been approved by either RD or NCLT upon reference to the NCLT. And ROC shall record the scheme and take it on record. So here, effect of this provision is like moment this order is taken on record by ROC by way of INC 28, meaning the transferor company shall cease to exist. The point which we discussed, that transferor company stands dissolved without the process of winding up. So that would be the operation of this form INC 28, because ROC will take it on record and mark that company as amalgamated in its master records, and then that company would become inactive for any filings and other compliances. So I think till 233(7), these are all critical provisions. Now onwards, there are few provisions which will quickly take it up, because I think we have 45 minutes more, so better we cover up other things as well. So 233(8) is we already discussed, dissolution of transferor company without process of winding up. 233(9) gives a statutory framework, what we just discussed in scheme, like whatever you write in the scheme, they are saying upon registration of scheme shall have the following effect, that property and liability of transferor company will become transferee company. If there are any charges registered on the property of transferor company, it will continue against the transferee company. Legal proceedings will be continued. And it says that if there are any dissenting shareholders or creditors, and scheme provides that such creditors be paid or shareholders be paid, then such unspent, undischarged liability will become liability of transferee company upon the scheme getting approved. So this is the effect of registration of the scheme. Like while whatever you have written in the scheme, that will also operate. And additionally, these are specific provisions under the law. Then Section 233(10) is a clarificatory provision which says that transferee companies shall not hold its own shares on merger. As all of us know, no company can held its own shares. So as we discussed in one of the examples, that if holding company merges into WOS, those shares will get cancelled, because the WOS cannot hold its own shares which were held by the holding company upon merger, and such share will have to be cancelled mandatorily. So treasury shares are not allowed. Earlier it was allowed by way of trust and like that. And 233(11) is an enabling provision. It says that transferee company shall file an application with ROC for aggregation of authorized share capital, and whatever fees was paid by transferor company on its authorized capital will be available as a set off. Then 233(2) is again, as we already discussed initially, that while heading of the section is mergers and amalgamation, Section 233(12) specifically provides that provisions of this section shall mutatis mutandis apply to a company or companies specified in subsection 1 in respect of any type of compromise or arrangement referred in Section 230. So Section 230 is very wide in coverage. Like any sort of compromise and arrangement between eligible companies can be done under 233 by virtue of 233(12). Similarly, division or transfer of a company, meaning demerger, as is commonly known under 232(1)(b), can be done under this section. 233 3313 is the enabling provision. Rule 25 has been notified that central government may provide for rules. And 23314 is the last section, and 25.8 is the last rule, a sub rule, which says that it is again a very important provision, like the example which we discussed, that there is a merger of wholly owned subsidiary company into the holding company, and these are listed companies. So holding company is a listed company, and then there are subsidiaries which is getting merged in the holding company. Now, though this is a merger between holding and subsidiary company, it's not necessary or mandatory for holding company and companies to follow the provisions of Section 233. They can always follow Section 232. So it is a clarificatory thing that even some companies are eligible, they can always follow Section 232 route. So that is possible. And in fact, in case of demerger, which is very critical, that generally we'll discuss in the income tax part, that demerger under 233 may be challenging from income tax neutrality point of view. So I think we completed this company law provisions related procedures. Now I think whatever we discuss right now in terms of timeline, that has been summarized in these two slides. Maybe like as we have discussed, this PPT will be distributed to all the participants. So maybe like whatever we have discussed, that has been captured in a summarized form. So once you see this PPT, you can always go through it. So technically, just summarily on a very high level, serial number 3, the whole activity will start with approval of scheme by the board of the companies. So like whatever activities you need to undertake, first board will have to approve it. And before that, minus 15, we have said, maybe some evaluation, appointment of agencies, advisors, registered valuers, routinizer, and preparatory work. So technically, you need to start minus 15 days before board needs to approve it. And by the time board approves it, all document must be in place. And then you will issue notice to regulatory authorities, ROC, OLRD, 30 days advance notice as we discussed. So that goes on X plus 1 day. Declaration of solvency is also filed on X plus 1 day. And as we discussed the sorter route approach, that on X plus 1 day itself, we issue notice to members and creditors for convening the meeting. So there are forms, section, and rules which have been listed down. And with by 30 days, we need to receive the objections and suggestions from the regulatory authority. And on X plus 32 days or 35 days, you can have a members meeting or creditors meeting. And within 7 days thereafter, you need to file application with RD, ROC, OL, so X plus 39. Then RD, ROCOL will communicate its objections within 30 days, so X plus 69, and approval of the scheme by RD within 30 days thereafter. So broadly 100 days time frame you can say. 10 days generally lag between the statutory timelines, and 30 days. So you can understand like that. So 30 days before meeting, 30 days ROCOL approval, objections, and after 30 days RD approval, and 10 days lag in between. So within 100 days, you can technically complete this process. And once we get confirmation order from RD, there are post-approval formalities, which generally takes 30 days. So like filing of INC 28 with ROC for aggregation of authorized share capital, and then stamp duty adjudication application and implementation of other terms. Like say, if you have to issue shares to the shareholders of the transferor company, and record other things. So all those things you will do within 30 days. So technically within 4 months, 120 to 130 days, this process can be completed, which 8 to 12 months, which generally NCLT takes nowadays, because there are a lot of queue at NCLT, and generally it takes longer than expected before NCLT to approve a merger. So here, reasonably within 4 to 5 months, you can have a merger scheme implemented coordination with all authorities, agencies, and internal work that is doable. And here it is an alternative procedure that if say RD does not approve the scheme, then it will have to file an application with NCLT. And obviously, in that case, LCLT may take its own time. So we are reasonably assuming that NCLT may take 60 days time minimum to consider the scheme. So the process may get delayed, and it may take some say 6 to 7 months. That is what we have just listed down over here. So I think we are done with these company law provisions. We'll go to other sections. Before that, I think we have almost discussed all these critical points: declaration of solvency, approval of scheme by requisite majority, timelines to be strictly followed, RD cannot reject the scheme. And here, this is Asset Auto India Private Limited was a judgment wherein NCLT had approved, so RD had rejected the scheme. Companies filed an application before NCLT on the grounds of this declaration of solvency only. And NCLT approved the scheme, saying that RD does not have power to reject any scheme. It has to either approve it or make an application before NCLT, which companies have made. And now, in the opinion of NCLT, no public interest is affected, and NCLT had approved the scheme. So against that, RD filed an appeal before the Bombay High Court, and Bombay High Court again upheld the ruling of NCLT. So now this is the law of land, so to say. It's a very recent judgment, August 2024. So in that sense, RD may not have power to reject a scheme. Either way, it will follow. Either it will approve it, or the matter will be referred to NCLT. So maybe now we will go to some other key areas for evaluation, and we have some 40 minutes or so. So I will just
For that,
quickly
Ankit,
look
can
at.
we just take up a couple of questions which are there in the Q&A on company law provisions?
Yeah, Prithvinder, certainly we can take it
Okay,
up. So
let me just go ahead with one of the question. Can the notice convening the meeting of creditors be called through email rather than sending physical notices?
yeah, that is currently possible. Like in fact, so like this procedural part is identical for all other processes. Like say under the general company law provisions nowadays, any meeting of members and creditors can be called through email. I mean, so the notice can be sent through email. Right now, that relaxation is there, so that equally applies to fast track merger as well. So currently, yes, I mean, there are special circulars which ROC has issued, and unless that circulars are taken back or no longer becomes effective, operative, then you will have to send physical notices. But currently, through email is possible.
Okay, can you
And,
please clarify that net worth is as of which date needs to be seen? I believe it is for small company.
yeah. So again, I think maybe from overall perspective, there are two angles to it then. So one is the declaration of solvency perspective, maybe people is asking from that perspective or either way. Or second is small company criteria. So what has been generally seen, like say there are two critical dates as we can see in the entire process. One is when the scheme is approved by board, right? That is the time when I mean matter comes up for evaluation or on record. So that is one date, and another is the appointed date. So now widely it is understood that on the date of approval by the board, if you are able to fulfill this criteria, either criteria in terms of declaration of solvency, net worth, so something like say we are in the month of November. Now say in March 24 there was a negative net worth. But because of subsequent event, net worth has become positive, say sometime in July, August. Then companies has that leeway because nothing is specified in explicitly. So what you can do, you can always have a audited or maybe limited reviewed financials or even management certified financials as on latest date, which reflects positive net worth. And then you can have a declaration of solvency on that basis. Or for small companies criteria, maybe if that question is from that perspective. So again, when board is approving the scheme, maybe companies can reasonably take that stand that when scheme is approved by, considered and approved by board and members, that would be the relevant date when we need to test all these criteria, because nothing is explicitly mentioned in the law. And I think that is the stand generally parties are taking in the industry. But obviously, when you are planning, it is always advisable that you try to accomplish this criteria as on the appointed date, as well as when the scheme is considered and approved by members and board, if possible. Otherwise, you will have to take a stand. Yeah,
Member,
Preeti.
if the company is a small company and meeting all the criteria up to the date of approval, but at the time of filing or the hearing, when the hearing comes, or when you have to make submissions to RD, if by that you no longer remain a small company or you cross the bridge, then what happens?
So here, so technically, what we will have to see, there are very famous Supreme Court judgment on Marshall and Sons. on the effect of mergers and amalgamation, though it was in the context of Income Tax Act. And on the same lines, there are many other judgments which has come over a period of time. So effectively, what it says that company, transferor company ceases to exist from the appointed date. So
Okay.
that is the effect of scheme of arrangement. So point is like though, like say, just to take it of a practical scenario, 1st April 2024 is the appointed date. We are right now in the November month. So
Yeah.
now on 1st April 24, November 24, companies are small and say approval takes time till March 25.
Yeah.
Now I'm talking legal procedures, legal provisions. While practically you may face difficulties with regulators, but if you have to go by the law of the land, so to say the judicial precedent and standing on that, so it says that if merger is approved in March 25, it takes effect from 1st April 24, meaning that company ceases to exist from April 1, 2024. Once it is approved, no doubt, till the time it is not approved, company continues to survive and exist. But once scheme is approved, scheme takes effect from the appointed date. So what I'm just trying to say that you may be legally able to justify that once scheme is approved, it will take effect from 1st April 24, and all transaction which is done by transferor company becomes the transactions of the transferee company. And in that sense, you are eligible. So that is the stand one will have to take.
Okay. There's
But
one question.
obviously, RDROC will have its own objections, which you will have to
Correct.
manage. Yeah.
Yeah. There's one more question. Can one WOS merge with another WOS under Section 233? It's a sister concern whether one subsidiary can merge with the other subsidiary under 233.
No, so we have four limbs under this 233(1). So one is merger between holding company and subsidiary. You can't do under that provision, definitely,
Yeah.
because two sister fellow subsidiaries are not technically holding and subsidiary company. So,
Correct.
but if these two companies are either small
All or
companies or
startup.
startup, then you can do it.
Okay.
Otherwise, not possible.
I had just one more extension of the first question which was there. If
Hmm.
company A has a wholly owned subsidiary which is B Limited, both are in India. B Limited has a wholly owned subsidiary, C Limited, which is outside India. The merger is of A with B or B with A. Whether it is
Hmm.
permissible or not, because if B is merging with A Limited, then obviously it's C Limited will become direct subsidiary of A Limited with a
Yeah,
merger.
so
So that is
correct.
permissible or not under FEMA? I mean,
Yeah, certainly it would be permissible from company law perspective because it doesn't matter like whatever assets or liabilities that company B may be holding.
yeah,
One of that asset happens to be company C, which is a subsidiary company located outside India.
yeah,
So definitely merger between A and B is possible within the Indian jurisdiction. Only thing, the notice which you need to send to the person affected by the scheme.
yeah.
In that case, you will have to submit that notice with RBI as well. If RBI has any objections to it, in the sense that there is a foreign asset which is held by company B, now that asset will be held by company A. So if under FEMA provisions or otherwise, if there are any issues or any non-compliance, then you may face that limitations. Otherwise, from company law perspective, it is doable.
Okay. Can two NBFCs be merged under fast track route? Both the NBFCs are within the capital and turnover threshold prescribed for small companies.
Yeah, certainly. Under the company set, you can do. Again, you will have to send this 30 days advance notice to RBI. And generally, what we have observed, RBI is very particular about such instances. So it may allow, not allow, it depends. So that advance 30 days notice, you will come to know. And generally, irrespective of the company law provision, when there is a change in shareholding of NBFCs, you need to take prior approval of RBI. So it's not something like you just send 30 days advance. So just to answer this question, under the company law, possible. Now, as far as NBFC and sectoral regulator, RBI and NBFC related provisions are concerned, you will have to approach RBI, take their prior approval, not under the company law provisions, but otherwise. And only if that approval is in place, you initiate the process under the company law. Because you can't just say that if RBI does not come up within 30 days and you just go ahead and do the merger. In one case, what we had seen, we had filed similar application with RBI. RBI said that right now we will not give any comment. You come up once merger is approved, and after we went to RBI, it says that now I don't want to approve this merger. And there was a time lag between two events.
Okay.
So such situations can occur, and we have to be mindful whenever a sectoral regulator is involved.
Correct. And one more question is there whether FTA applicable in case of NBFC?
Sorry, what is FTA?
Fast track approval. It could be
approval.
fast track approval. So that seems to be one and the
Okay.
same question.
Yeah,
which
yeah,
is
yeah, same thing.
applicable subject to sectoral approval. Arre baap re, there are
Correct, correct.
questions. What is the latest date that can be considered for preparing the statement of assets and liabilities for declaration of solvency, I believe?
I mean, it is a practical thing. So you can do as last as yesterday also, or maybe obviously last audited would be a last benchmark. So if we are in the month of November, generally last audited financials is generally seen. And I think for declaration of solvency format itself, there are certain criteria. Maybe we'll have to just factor that, because sometimes it is quite possible that on 31st March, there was a positive net worth. But if the latest position is little different, because generally RDROC also asks for it, latest financials. So one will have to be mindful that if there are any variation in the financial position between the last audited and the latest date, you will have to see it that criteria is met on both the dates. I mean, point is whether you do it or not, because there are no specific provisions. RDROC can always ask for it during the approval process, that what is the latest and current position. Accordingly, you can follow it. So, yeah. And next question is, what is whether benefit of take can be availed in case of small company merging with a NBFC? Yeah, if that small company and NBFC both are small companies or startup company, you can have. So principally, you need to fall within those four category of companies. Either it has to be holding an WOS, or two small companies, two startup company, or startup and small company, irrespective of the status of the company or the business it is doing. Say NBFC, or some insurance business, or merchant banking business, or maybe something like listed company. So all those provisions are possible. Just that you need to fall under these four categories. But will RD consider NBFC as small companies? Generally, say nowadays NBFC. So there is one question which says that but RD consider NBFC as small companies. So you will have to independently test that. If say NBFC has sizable net worth, so obviously it won't be a small company. So there is a definition of small company under the Companies Act. It's a very specific thing. It's not subjective. So if you are able to fulfill those criteria, small company criteria, then though you are an NBFC, you can consider it. But generally NBFCs would have sizable net worth, as we understand, and it may not meet the criteria of small company. But that is something we'll have to test independently. There is a turnover and net worth criteria, so which one will have to see.
Okay, let's move ahead.
So basically, paid up share capital is 4 crore, and 40 crore is the turnover. So I think 40 crore is the turnover. So I think these are the criteria for NBFC. So if they are within these limits, you can do it. So other key areas for evaluation, quickly touching of while now just to give a perspective, while there are few slides which all of you will get, so we'll not deep dive into those slides, and we'll just touch upon the important aspects only. So like for income tax, we have some 9-10 slides for there are detailed evaluation on merger demerger. So we are not going to touch each and every aspect. Rather, so point is, like other areas for other key areas for evaluation. So like while we saw the company law provisions, like how the process will run and whether we can do it or not, at the same time these are the factors which are very important, equally important to be evaluated. Because while say from company law perspective certain things may be viable, but it may not be tax efficient, say from income tax point of view, or maybe say some other law perspective, FEMA, as we just discussed, then we have to be mindful about such parameters. So generally what we do when we do such assignments, these are the factors, very commonly known factors, which are generally evaluated. That what would be the implication under the Income Tax Act. So these are the monetary factors. So these components can have monetary impact or cost impact on the scheme or the overall transaction. And then there are non-monetary factors, which are more of a compliance perspective. So we generally have to look at income tax implications, GST, stamp duty. So we'll just touch upon quickly on GST and stamp duty in one slide later on, and then transfer premium and other charges. So like say often there are certain asset where if you change the shareholding or control base, so something like MIDC land or JIDC land, any Industrial Development Corporation land. So there are conditions that if there is a change in shareholding of the company which owns such land, then you need to pay transfer premium to the authority, which runs into 10% or so maybe of the value of the asset. So you'll have to evaluate such things, whether while merger is operationally possible, but that should not involve unnecessary cost. And change of control clauses. So like say if the companies involved in the scheme has certain critical contracts, maybe with some MNCs or maybe some leading players, or say some government contract within India. So generally there are clauses in such contracts which says that if there is a change in control of companies, meaning a change in shareholding of the company, or even like say bank sanction letters, so then you need to take their approval, respective regulators approval. So we'll need to duly evaluate such, and sometimes such control clauses can have monetary impact, because say if you lose a valuable contract, then you are sense you have to be mindfully evaluate all these factors. On the non-monetary factors, you have SEBI laws. If there is a listed company and there is a merger of wholly owned subsidiaries, there are SEBI regulations which you need to duly comply with. FEMA laws, as we just touched upon, while inbound outbound merger is not possible, but in a very last example which we discussed, A, B, and C, C is located outside India. So obviously there is a change in shareholding of C from B to A. So maybe, and if A and B are into different business, and then there are certain FEMA law provisions which are specific to certain businesses, then you will have to duly evaluate whether there are any limitations or any additional approval which you need to follow under FEMA law. Competition Commission would generally not come because these are small companies. Generally, there are higher threshold for Competition Commission approval to be involved. And then there are other sectoral regulators, as we have been discussing, RBI, SEBI, for insurance companies, RERA, MIB, Ministry of Information and Broadcasting. So like say if companies have news channels, like if any companies own any channel, then you need to generally take MIB approval, Ministry of Information Broadcasting. And then there are accounting treatment, as we already touched upon initially, pooling of interest method and purchase method. So depending on method which you follow, there could be non-monetary and monetary implication. Because say if companies choose to adopt purchase method of accounting, right, which is possible under the accounting standard, then like say you can, this can result into monetary impact, because say the transferee company can record such assets or liabilities which it has received under a scheme at fair value. And then your MAT implications, as some of you may be aware that there are MAT implications on the book profit. So by that way, you can such fair value accounting can impact the book profit, and you can have a monetary impact in terms of MAT implications and things like that. So accounting treatment, while it is a compliance thing, it could lead to monetary or non-monetary implications. Now, I think there are a lot of slides on amalgamation under the ITA. Just critically, what we will discuss is that fast track. So there is no distinction under the ITA between fast track merger and regular merger. So what all income tax law requires is that Section 2(1)(b) definition should be complied with. So say a merger may be a fast track merger under the company law provision, but not necessarily it should be an amalgamation under the Income Tax Act. And generally, you need to ensure that your scheme of arrangement between two companies comply with conditions of Section 2(1)(b) in order to ensure that your entire process is tax neutral. Otherwise, there could be a lot of tax implications at different level. Like say, there could be tax implications to transferor company, transferee company, as well as the shareholders of the companies. So Section 21B requires certain conditions to be fulfilled. Merger of two companies, all properties and liabilities should be transferred. Shareholders holding not less than three-fourths in value of share in the amalgamating company should become the shareholders in the amalgamated company. So it is possible that not all shareholders become the shareholders of the amalgamated company. So there could be minority shareholders to whom you may provide that instead of issuance of shares of the transferee company or amalgamated company, you will pay the monetary consideration. So here there is a leeway that at least three-fourths, 75% of the shareholders should become shareholder. And then there are multiple areas which we have just listed down, like here you can see. So shares can be preferences also. Shareholders should be as an appointed date or effective date. And merger of fellow subsidiary companies have some implications. So I think these are the criteria which you need to fulfill from income tax perspective. And this is not very specific to fast track merger. Any merger will require these conditions to be fulfilled in order to have tax neutrality under the law, income tax law. So there is, once you comply with section 21B definition, these three conditions, then under section 47(6), there is exemption given to amalgamating company, because effectively there is a transfer from amalgamating company to amalgamated company. Similarly, amalgamated company would receive certain assets without discharging any consideration to amalgamating company. So again, 56 to 10 has that exemption that any transaction covered by 47(6), 6A, 6AB is exempt. Similarly, for shareholders under 47(7), there is an exemption. And I think section 49(2) deals with allocation of cost. Like, so basically not allocation of cost here, whatever cost of acquisition of transferor company was there, that will become cost of acquisition in the transferee company. And then there are certain critical areas which you can see by four small boxes. Monetary consideration taxable subsidiary of amalgamate company. So these are very typical issues under the Income Tax Act. So maybe right now we are running short of time. So maybe we may not be able to deal with each point in detail. But conceptually, once merger is qualified merger under 21B, you have all the exemptions available. And here there are some points which we have covered, like grandfathering may not be available, say listed in case of listed companies. And then there are, so then carry forward of losses, there are certain conditions in which case, like when there is a merger between two companies. So first of all, section 72A requires that there has to be an industrial undertaking. So only if this transferor company has industrial undertaking, then you have the benefit of carry forward of business loss and unabsorbed depreciation is available. And subject to all these conditions, which has been listed down, fresh lease of life. So meaning generally, as you know, that there are 8 years up to which losses can be carried forward. But if you comply with this 72(1)(b) definition and 72A provisions, and the whatever losses are there in the transferor company, that would become the losses of transferee company of the year in which merger takes place. So you will have the new life of 8 years from that day onwards. And conditions for amalgamating companies, so like what all conditions amalgamating companies should comply with and what all conditions amalgamated companies should comply with. So technically there is the scope is very restricted. So like say if there are service industry company or companies which are into trading activities, to them this benefit will not be available, because the prerequisite condition is on this right side. You can see it says that industrial undertaking has to be there, meaning manufacturing of goods, computer software, generation of electricity, telecommunication service, or construction. Only these entities, meaning transferor companies engage in this business, can have this benefit. Otherwise, carry forward of losses generally would not be available in other case of mergers. I think we'll skip this very specific provisions to relating to MET. Similarly, under the demerger, you have section 219 AA definition, which you need to comply with. Once you comply with those conditions, you have tax neutrality to amalgamating, amalgamated, and shareholders, and some other provisions. So while section 21B is there are very limited conditions, only 2-3 conditions to be made, and generally all mergers will comply with those conditions. But demerger So very important point, what we were discussing earlier when we were going through Section 233 provisions. So here under demerger, Section 219 AA, there is a definition of demerger, which says that demerger means transfer pursuant to a scheme of arrangement under Section 391 to 394 of the Companies Act by a demerged company of its one or more undertaking to resulting company in such manner that you comply with condition 1, 2, 3, 4, 5, 6. There are 6 conditions. Before that, whether fast track demerger covered. So recently we were evaluating one case, and I think if you look at here language, there is no substitution of language. So right now, still as on date, under the Income Tax Act, all language is appearing, wherein it says that scheme of arrangement under section 391 to 394 of the Companies Act. So if you look at the transitional provision when Companies Act 2013 was enacted, and if you look at the General Clauses Act where interpretations have been given, so it says that 391 to 394 is replaced by section 232, 232. So now section 233 will not be covered by this language. So on a conservative note, if one has to go by it, one would take a stand that a demerger done under FTM provisions under section 233 technically may not be covered by this definition of demerger because it is not a scheme of arrangement under 391 to 394 or so to say section 232 232. So whereas FTM is governed by 233. So this is the very key thing. And in one of the case, looking at the tax implications, we did not pursue section 233 route and instead we gone ahead with section 232 route because say if you go ahead and implement a demerger scheme like this and tomorrow if income tax department during the approval process or maybe post approval during scrutiny assessment. Like if they go on this technical ground and say that this demerger is technically not a demerger under the Income Tax Act because of this language, then there are lot of tax inefficiencies. There is a famous Grasim Industries case. You can any one of you can search on the net when there was a demerger of Aditya Birla Capital from Grasim, and department had took a stand that that demerger was not compliant on some other ground, not on this ground. So it was saying that there was no business undertaking in that particular scheme, and there were liabilities running into 5,000, 10,000 crore on the Grasim Industries Aditya Birla. Because of that, finally, the matter has been upheld in favor of the Grasim Industries. However, point here is if a demerger is upheld to be not a demerger under the Income Tax Act, not a compliant demerger, then tax implications could be very severe. So because of that, you have to take a very thoughtful decision before you start implementing the scheme. So here conditions are all properties and liabilities should be transferred, and I think we have just discussed what all things should be taken care. Here, there is no leeway under clause second provision that all such properties and liabilities has to be transferred at book value only. So, like say what accounting treatment we discuss that you can do fair value accounting in demerger, that is not possible because if you can do it under the company law, but then it won't be a tax neutral demerger under the Income Tax Act. However, there is an exception for Ind AS companies because under Ind AS, if companies are independent, they have to follow the fair value accounting. So you can't do book value accounting. So there is an exception for Ind AS companies, and then there is corresponding provisions under MAT, which government has taken care of. So these are two conditions: all asset and liability, property and liability should transfer. They should be transferred at book value only. Then you have the resulting company has to issue shares proportionately to the shareholders of the demerged company. Again, 3/4 of the shareholders should become shareholders and transfer of undertaking on a going concern. So this was the case that there should be a business undertaking and it should be transferred on a going concern basis. So the Grasim Industries case, which we were just referring, there was a challenge on this ground saying that there was no business undertaking involved in such scheme and only mere holdings were there, investments were there, which cannot be qualified to be an undertaking. And there is a residual condition, demerger to be in compliance with such conditions as is notified under 72A5. However, as on date, no such conditions are yet notified. So these are the conditions, 6 conditions which you need to comply with. Once you comply with that, your demerger under company law will also be a qualified demerger under the Income Tax Act. And then you will have all benefit 47 6B and 56 to exemption to demerger and resulting company, demerge and resulting company. And similarly to the shareholders, like whatever shares, like say shareholders of demerged company would receive shares of resulting company because of the demerger. So like whatever shares they receive, that is not taxable, and there is a mechanism for allocation of cost, like how the cost will be allocated. And I think uh, so what happens when a demerger is not qualified to be a demerger under the Income Tax Act? What effectively it department treats is that the resulting company receives a division from the demerged company, and ideally, resulting company was supposed to discharge consideration to the demerged company. And instead of that, resulting company issues says to the shareholders of the demerged company. So there is a two layer of taxation. What it says that there is a transfer of undertaking from resulting demerged company to resulting company, and there is a tax liability on the resulting company on that, as if it has transferred an undertaking by a slump sale, so to say, or itemized sale. And now again, that resulting company has issued distributed those funds to the say its shareholders. So that is a dividend distribution. So there are multi-layer taxation if a demerger is not qualified to be a demerger under the income tax law. So these are, I think, multiple layer of taxation is there. There is a mechanism of cost allocation under section 49 to C, how the cost will be allocated, so that we have period of holding shall also be considered for 242A. And I think these are some specific provisions. So like, I mean, now we are on last two slides only. We have 10 minutes. So we'll quickly touch upon these two slides. Maybe stamp duty provisions quickly. So like, as we initially discussed, a scheme of arrangement is a contractual document between companies and shareholders and creditors. So in that sense, it is an instrument as such term is defined under the stamp duty laws. So stamp duty law says that any instrument, meaning any agreement, when it is executed, there is a levy of stamp duty on such agreement. Like say, if you do a sale deed, we need to pay 5% stamp duty under the Maharashtra Stamp Act in India, in Mumbai, say for example. So similarly, scheme of arrangement has effect of transferring property from transferor company to transferee company. And accordingly, such schemes should be treated as an instrument and on which stamp duty is payable. So hence it is a chargeable. It is a very established law. I mean, since 2004, Hindustan Lever case was there, and earlier companies used to take a stand that there is no instrument, but a provision is very clear now, and there are specific provisions in some of the Stamp Act, state-specific stamp law, like in Maharashtra. So stamp duty is a state subject, so it is not a central law. So each state will have its own provisions. So we'll have to be mindful like where companies are located, and accordingly stamp duty provisions will follow. So like say in Maharashtra, you have this Article 25, wherein it says that when there is a merger or a scheme of arrangement between companies, generally stamp duty is 10% of the value of shares issued by the transferee company or the resulting company, as you may call it. So to say, like say you will have a valuation report, right? So say for example, there is a transferor company whose value is 10 crores, say for example, as per that valuation report. Now transferee company will issue shares worth 10 crore. So on that 10% stamp duty is applicable. So 1 crore stamp duty would generally come. However, this is subject to maximum of two provisions A and B. So it says that subject to 5% of the value of immovable property transferred from the transferor company. So like say in a scheme of arrangement, assuming there are no, say for example, there is a immovable property worth 1 crore in the transferor company. So 5% of that would be 5 lakh rupee only. So this 10% is subject to 5% of value of immovable property which is getting transferred from transferor company to transferee company, or 0.7% of the value of shares issued by the transferee company. So I think these are the, so while generally in most cases 10% does not come into picture, uh, generally you will have 5% of the value of immovable property or 0.7%. In very rare cases, 10% provision may come into picture, because 5% of the immovable property could be such a way substantial that it is more than 10% of the value of share issued. So in that case, stamp duty would be restricted to 10%. So these are the legal provisions. I think whenever you happen to work on such transaction, this is the tax implications in Maharashtra. But say when you do a merger of wholly owned subsidiary company into holding company, you will not have any tax implications because there are no shares issued. So this language, 10% of the value of shares issued, will not come into play because there are no shares issued. So even if you apply 10% of zero, you will get zero only. And this is practically done, and there are no issues in this. Whenever there is a merger of wholly owned subsidiary companies, irrespective of the value of immovable property, which WOS may be owning, because so long as there are no shares issued, there can't be any stamp duty implications, at least under the Maharashtra Stamp Act. Other state, we will have to specifically evaluate. As far as procedural part is concerned, there is ADJ1 adjudication form which needs to be filed. In terms of timeline also, we had said whenever there is an order of RD or NCLT, you need to file that scheme, order of authority along with certified copy of scheme with the stamp duty authorities, along with some supporting documents like affidavit, undertaking, valuation report, financial statement. And generally, as we have observed in Maharashtra, STEM department is very lacking and very inactive. So even if you file an application, you will not get any response for months and years. So you will have to effectively coordinate and get the work done. Otherwise, order may be passed even after 2 years. And at that time, you may have substantial liability also. So practically, we have seen this is one department where you need to pay more attention to get the adjudication done as soon as possible. So I think these were stamp duty provisions. Generally, it is an scheme is an instrument chargeable to stamp duty. There are specific stamp duty laws under respective state which provides for quantum of stamp duty payable on such transactions. And to determine that, you have to file an application with stamp duty authority. So they will just go through all document and confirm that this is the amount which you need to pay. And after they pass an order, you need to pay that stamp duty. Say after the final order is passed. And then this is the last slide. We have just 2-3 minutes. So we'll just quickly, these are practical and operational challenges which one would generally face when you. So first point is intercompany transactions during the scheme implementation period. So one of the example which we took, that appointed date is 1st April 2024 and the scheme is approved in March 25. So, and as per this legal judicial precedent, scheme takes effect from the appointed date. So whatever transactions are there in between these two companies which are going to merge, whether you need to do TDS compliances, whether if there are any company law approvals required, whether you need to take it. So technically, we generally, as a precaution, we keep doing it because you never know that whether matter will be approved tomorrow or not. And for some reason, say if something you are not able to comply with very technically and some escapes are there, then maybe one would be able to take a stand down the line once merger is approved, that finally whatever intercompany transactions were there, that has no relevance, because with effect from the appointed date, whatever transactions which transferor company did, that was effectively done on behalf of the transferee company. So this is something deep dividend says, and say for example, WOS gives loan to the holding company. So there is a dim dividend concept. Like say if you want to, there is no leeway available and there are funds available with WOS and you want to use it at holding company level, then if merger is not in place, you have dim dividend implications. But one may be able to take an argument that with effect from the appointed date, this merger got effective and dim dividend should not come into play. So one provision which we could not discuss earlier is under the Income Tax Act, Section 170A is there. There is a specific provision which has been introduced recently, last 2-3 years, which says that whenever there is a merger of companies, the transferee company can file ITR-A, which is a modified return, wherein the ITR of companies are updated in the sense whatever transactions were there, say computation of income of transferor company, will be consolidated with transferee company, and it is effectively a modified or revised return, so to say. So ITR-A is the form, and Section 170A is the provision, which says that whatever period is covered by the scheme, after scheme means after the appointed date, you can file the return under that. So when you file those returns, there is provision that you can transfer TDS credit, which is which is reflected to the credit of transferor company. So under ITR itself, you can transfer TDS credit from transferor company to transferee company. However, if any advance tax was paid by transferor company, then technically you will need to get it transferred from AO, because say it would be in the name of in the pen of transferor company, and if you use that advance tax challan in the return of transferee company, there will be an error because system will not accept it. So you will have to make an application to jurisdictional AO and change the pen on the grounds of scheme and all that thing. For need for continuation of bank account of transferor company, while legally transferor company ceases to exist, but operationally you can continue to retain that bank account for reasonable period, say maybe something like 3, 6, 9 months, saying and whatever transactions are done in that bank account, that would be deemed to be done effectively for transferee company, because say, there are some old income tax refunds due. So as you know, in the CPC system, the refund automatically goes to the bank account which was mentioned in the ITR. So if you close the bank account of transferor company, then there are practical challenges that you may not get the refund, and you will have to take additional actions for that. So if that account is live, though you may not actively do any transactions, it will remain non-operational. But if need be, such transactions can get covered. Like say if you have an old check, right, post-dated check you had taken from customers. Now that client, that party may not give you the fresh check, or there are some issues. So you can always deposit that check in if you have retained the bank account. And then if it bounces, then you can initiate check bouncing procedures against that. But if that bank account is closed, you won't be able to do it because you need to have it. And similarly for many other things, it's important that bank account is retained. And similarly, other, like say last point I am just taking up, other statutory registrations filing, you should retain it. Like say PAN, you should not surrender immediately. GST registration, because there could be some past events which you may need to do. And once you surrender any such thing, you won't be able to take actions. While legally transferee company can take actions on behalf of transferor company, but operationally we have seen there are limitations, because everything is linked to unique numbers, PAN, GST, or other unique number, and we face difficulties. So if we have retained such registrations, you can always do it. And that work is effectively done by transferee company. It will be legally, it will be deemed so. And then as far as GST credit is concerned, there is specific provision under section 18(3) rule 41(2), like whatever GST credit is there, that can be transferred from transferor company to transferee company by filing form ITC 02. And another point is this entire scheme of arrangement transaction is a non-taxable transfer under the GST law. So like say if you have hired any advisors and if you are making any payment to them, so whatever expenses are there, effectively it would be for a non-taxable transaction, and you may not be able to take GST credit for that if you strictly go by the provisions of law. And similarly, last point is vendor registration with customers, suppliers. So you need to plan in advance before effective date comes and transferor company ceases to undertake operate effectively. You need to in advance get all these registrations done with customers, vendors, because often we have seen there are these transitional issues and business gets impacted if you don't do or well plan it in advance. So I think this was some of the uh, practical issues, I think, and obviously many of you while doing such transaction may have come across similar issues, and we can always chat or interact on this email. So yes, Prithiven, so I think we are done with this session, and maybe if there are any questions, we can take it up.
So when there's one more question, Ankit. It says if 100% subsidiary company is merging into holding company, whether stamp duty is applicable if subsidiary company owns immovable property. Then there are
No,
no shares issue, but property is there.
yeah, sure. So Ashok, I mean, Ashokji has raised this query. So definitely, as we mentioned, so long as there are no issue of shares, there can't be any stamp duty implications, and we have successfully done many such transactions. So there are practically also no issues. So say you, so one thing is stamp duty is not applicable there, but procedurally you need to do all these compliances. You will need to file form ADJ 1 with the stamp duty authority, and then they will adjudicate the order for 100 rupees. And you will pay that 100 rupees, and using that adjudication order, you can always get the property records updated from the name of transferor company to transferee company without any stamp duty.
Okay. So, thank you so much, Ankit. Thanks, participants. Before I give a pleasant task of presenting a hearty vote of thanks to the speaker. I have certain information or the announcements to share about the forthcoming events of the committee. There is on 29th 2024, we have a NPO Conclave 2.0 at Mayor's Hall, Andheri West. Then the next study circle meeting is on 10th of December 2024, which is on professional opportunities for CAs in insolvency and bankruptcy. On 4th January 2025, we have a workshop on succession and estate planning at IMC Churchgate. And on 17th and 18th January 2025, we have a AIF conclave at Hotel Ginger near Mumbai Airport. Now comes the pleasant task of presenting a hearty vote of thanks. You all will agree that today's session was Gagar Mein Sagar. Ankit Bhai has covered the whole gamut of fast track merger within such a short time, elaborately explaining all the procedural aspects, touching upon all practical aspects as well. And we all are enlightened and thankful and delighted. Thank you, Ankit Bhai. We give you a very loud round of applause. And participants, a small request, be a good citizen and please, please, please cast your vote wisely on 20th in Maharashtra. And also at the institute level, we have a election in December 1st week, I think 6th and 7th. So please give an effective vote to the leadership also. And thank you all.